My name is Larry Pikus. I'm one of the partners in the Labor Employment Benefits Group at Wigan and Dana. We are going to run through a series of different topics for you, relatively short presentations, probably about 15, 20 minutes each. You'll have the opportunity to ask questions through the chat, and we welcome those. A couple of just preliminary matters before we get started. After the event, we'll be sending an email with a survey that will also include a recording of the seminar. So if you have to step out or you missed part of it, or you want to share it with colleagues, that's great. We do encourage you to complete the surveys. Let us know what you liked, what you didn't like, and perhaps most importantly, what you'd like to see in the future. And subsequent programs, we do read those, and we do try and be responsive to those requests. Also, our application for HRC iCredit is still pending. Once we get word on that, we will let all the attendees know how to obtain that credit. So in terms of the program this morning, we're going to begin with Caroline Park, who is going to talk about developments at the EEOC, of which there are a good number already. I'm going to back that up at the end for a presentation, talk a very little bit about arbitration, which is still a very prominent issue where we've talked about it before. Then we're going to pivot into a specific COVID-related discussion about vaccination policies, with the vaccine being rolled out at a fairly rapid pace now. At least it's starting to pick up, and you probably heard yesterday the J&J vaccine got emergency authorization, so that will probably expedite things as well. We're going to be talking about what sort of policies you might want to consider for dealing with vaccinations of your workforce. Then we're going to move into an area that we usually don't talk about at our seminars, quite frankly, which is workplace safety issues and what's new at Osha. Mike Miller is going to talk to you about that. Obviously, workplace safety has become a more prominent issue in light of COVID, and we thought that would be a good topic to talk about. It's pertinent to most, if not all, workforces. We'll take a short break at that point, give you a chance to address some emails or whatever you might need to do. We'll come back, and Josh Wyatt will talk to you about what's going on at the National Labor Relations Board, which is another area where you can expect, at least down the road, to see some pretty significant changes in approach. Najib Khalid will talk about immigration matters, another subject we don't usually get into, but with the change in administration has become much more prominent these days. And then Mary Gambardell is going to wrap it up with a discussion about wage and hour matters and what we expect to see from the Department of Labor going forward in the new administration, which, like the Nlrb, I think you'll see pretty significant changes in approach. So with that, I will turn it over to Caroline to get us started. Thanks.
Thanks, Larry. So we can go to the next slide if you wouldn't mind to get started. I'm going to talk about some changes that we've already seen at the EEOC and that we can expect that may come over the course of the next couple of years. So first, there's been a lot of shakeup in terms of leadership positions at different federal agencies, and the EEOC was no exception. If you'd go to the next slide, please. So the EEOC has 5 commissioners. They're all presidentially appointed, and they serve designated terms that didn't come to an end with the end of the last presidential administration. So we are left with 3 Republican commissioners at the EEOC and 2 democratically appointed commissioners. So we've got a Republican majority at the EEOC, which might suggest that changes to EEOC priorities may be a little slower than we could see at other agencies. The EEOC also has a strategic enforcement plan, which is going to be in place until 2022. So that kind of dictates the agency's enforcement priorities. So we, don't expect to see major overnight changes. It's also our understanding that the 5 commissioners aren't really butting heads necessarily over the direction it expects the agency to see in the next couple of years. So while there's a shakeup, maybe not as dramatic as the one at the NLRB that Josh will tell you about a little bit later. Charlotte Burroughs has been appointed as the chair. She is one of the commissioners appointed under a Democratic president. She's given a speech that we can, for what it's worth, highlights where she might try to focus the agency's priorities and efforts. She did address COVID-19 and the related workplace issues associated with it. She referred to it as a civil rights crisis, and plans to hold a hearing to address workplace concerns that stem from the pandemic. She also, and we'll talk about this in more detail, but she's kind of doubling down on efforts to investigate and enforce systemic discrimination. So they might be looking at larger class cases as opposed to individual plaintiff cases. You could go to the next slide, please. So this is not specific to the EEOC, but the Biden administration, when they came in, kind of hit pause on pending regulations across all agencies to allow basically new leadership to take stock of what was in the works before things went into effect. So for the EEOC, there were proposed rules that were kind of in limbo and had not yet been finalized that are now on hold. And those have to do with wellness programs. So these are the types of programs where an employer might offer an incentive of some kind to an employee or the employee's dependents through their health care program, basically encouraging things like regular physicals and monitoring of blood pressure and things like that. And historically, employers have been allowed to offer some form of incentive to get employees to participate in those programs on the theory that those kind of proactive health measures might overall reduce healthcare costs. So the rule had been set a kind of fairly high limit, about 30% that you could have as an incentive to participate in a wellness program. And there were some court cases finding that that standard didn't really allow for voluntary participation. If the benefit got to be so high, then employees really would have financial repercussions if they did not participate, then that takes away the voluntary nature of it. So these proposed regulations were to limit the reward to a de minimis standard. I mean, and de minimis, we don't exactly know what that means yet, but I think you can think like free water bottle instead of free credit on health insurance or some other financial gain for participating. So these are on pause. Again, we won't know exactly what will become of them. But I think for now, if you do operate a wellness program, I would track this closely because it does seem like we will get to a place where de minimis incentives will be the rule, even if something is rejiggered under these pending regulations. If you could go to the next slide. So another kind of immediate shakeup at the EEOC had to do with their mediation and conciliation programs. So there was a final rule that kind of eked through right before President Biden's inauguration that did get finalized, and that has to do with the conciliation process. And this is actually good news for employers. Under the new rule, employers are entitled to more information about a reasonable cause finding. So should the agency in the course of an investigation determine there's a reasonable cause to find that discrimination occurred, under this new rule, before an employer has to enter into a conciliation phase kind of blind, they're now entitled to more information about the factual basis for the cause finding. So from an employer's perspective, this is going to allow for a more informed strategy going into conciliation efforts. You're going to know what evidence the agency found so compelling as to issue a cause finding, know a little bit perhaps about the damages being claimed and how they're calculated. So the end result should be more informed conciliation efforts from an employer's perspective. So while that's good news, there were also some changes to the mediation program. There had been a pilot program that actually had been very successful and well-liked that was kind of abruptly canceled, except for some changes that are going to continue on. So one interesting part is, of course, the expanded use of technology. Given our current remote work arrangements, by and large, that is expected to continue. The EEOC will continue to use technology in order to have mediations virtually rather than in person. But otherwise, this is going to return to a slightly more restricted model for mediation. Instead of Instead of an opportunity to explore mediation throughout an investigative process, it's going to be more limited, again, to basically before the investigation begins. The next slide, please. So some of the changes that President Biden has already signaled came pretty immediately in the form of an executive order. So he issued an executive order on advancing racial equity. This was not limited to the employment area, but obviously was touched on. So the order is basically instructing the federal government to pursue a comprehensive approach to advancing equity for all, including people of color and others who've been historically underserved, marginalized, and adversely affected by persistent poverty and inequality. So that's the message kind of across different areas, but we can take that to also apply to what the agency's priorities will be in the employment era. This was coupled with rescinding President Trump's executive order, which was talked about and featured pretty widely, which was an instruction that federal contractors and recipients of federal grants were supposed to stop discussing, quote, divisive topics in the workplace, including trainings on diversity and inclusion. So while lots of different companies have stepped up their efforts to offer employee training on things like implicit bias, equity, inclusion, and topics like that, this executive order instructed at least federal contractors and grant recipients to stop providing such trainings, and included some pretty loaded language calling those types of training stereotyping and scapegoating on the basis of race or sex. So those two actions with regard to the executive orders show pretty dramatic change in terms of presidential position on those topics. The next slide, please. So I mentioned earlier from Commissioner Burroughs' speech, we know that the EEOC is going to be focusing efforts on cases of systemic discrimination. So to that end, they've already launched a new webpage on their site focused all about their efforts for systemic enforcement. So this is basically, they're on the lookout for disparate impact cases as opposed to necessarily disparate treatment cases. So policies that may have a disparate impact on certain members of protected classes as opposed to necessarily those individual plaintiff cases. So that site I'd recommend checking out just because the EEOC has put out there the steps that they're going to take for such investigations and how they're going to find the violations they think they're looking for. And they've said that includes their EEO-1 reports. So they apparently will be coming through EEO-1 reports to look for the types of trends that they might suggest to them there's a systemic discrimination issue that they are going to pursue. Next slide, please. So as a candidate, Biden proposed doubling the EEOC's funding. This is not something that is underway yet, but we can take that to mean perhaps increased enforcement activity. If he's successful in that campaign statement to increase funding, certainly that would allow the EEOC to double down on enforcement activity. So that is something to be aware of and to look at. Certainly, we will expect from the EEOC a focus on LGBT rights. Last summer, the Supreme Court ruled that sexual orientation discrimination is prohibited under Title VII, which on its face only prohibits discrimination on the basis of sex, among other protected classes, doesn't specifically address sexual orientation. But with that ruling, certainly we would expect to see the EEOC stepping up efforts to root out discrimination on the basis of sexual orientation. There is, as there always is, proposed legislation on a federal level to explicitly prohibit discrimination in employment on the basis of sexual orientation. That legislation has been proposed many, many times and has not ever been passed. It remains to be seen if following the Supreme Court ruling that could get a little bit more momentum. President Biden did say that he does strongly support the current iteration of that legislation. So should that pass Congress, Biden would absolutely be signing that into law. Something interesting in the currently proposed Equality Act is it's got some disclosure and reporting requirements that would require businesses to publicize the diversity of senior leadership and their workforce. So that would be kind of more public dissemination of information about companies' senior leadership, racial and gender makeup, things like that of their workforce. Next slide, please. So another thing kind of on our radar as we think about what we might see over the next few years is, of course, pay equity. Just like the Equality Act for sexual orientation, some version of this law has been introduced many, many times over the years. Again, this is another one that President Biden has committed to signing. This is the Paycheck Fairness Act. This would, on a federal level, require employers to demonstrate that wage differentials between men and women are based on factors other than sex. So it shifts the burden a bit in terms of what the current standards are under the Equal Pay Act and places a heavier burden on employers to justify pay differentials between men and women. It also prohibits retaliation against workers who inquire about wage practices or disclose their own wages, strengthens penalties for equal pay violations, and it prohibits employers from inquiring about salary history during the hiring process. That's a prohibition that many states have already moved on, so this would be implementing that on the federal level. They are also going to revive pay data collection and reporting requirements through the EEO1 survey, which was on temporarily suspended, I think as of May last year, and is going to resume in April of this year. Next slide, please. So in addition to the other proposed legislation I've talked about, there's another one floating out there, the Pregnant Workers Fairness Act. This also has President Biden's support. This legislation would require employers to offer employees increased accommodations at the workplace where their abilities are limited by pregnancy, childbirth, or a related condition. As a candidate, so not since January, but as a candidate, Biden said he supported reversing a Supreme Court ruling regarding age discrimination. You might remember about a decade or more ago, the Supreme Court ruled that in age discrimination cases, the burden is on the plaintiff to prove that age was a but-for cause for the adverse action. That's a slightly higher standard than what applies under Title VII. The idea here is Biden would support legislation that would take that age discrimination standard back down to the same standard applicable under Title VII cases of motivating factor rather than but-for. So in theory, that would make it a bit easier for plaintiffs to prove age discrimination and carry their burden, though I don't think we see any dramatic difference in the outcome of cases with the motivating factor and but-for cause standard. It's a little obscure. Next slide, please. So here is another piece of proposed legislation that Biden is also touting, which is the Be Heard Act. Stands for Bringing an End to Harassment by Enhancing Accountability and Rejecting Discrimination in the Workplace, but luckily has the handy acronym of Be Heard. So this legislation would extend protection against employment discrimination under Title VII to all employees. So it would remove the threshold size that's currently in place. It's also intended to broaden the current definition of employee. I think this is kind of motivated by the trends we see in the so-called gig economy of more and more people who are not necessarily W-2 employees, but who may be independent contractors, interns, or otherwise retained on some other basis other than employee that wouldn't necessarily be covered under Title VII as it stands now. Next slide, please. Oh, that's it. So I will turn it back to Larry. He's going to give an update about where we stand on arbitration.
Okay, thank you, Caroline. Many of you will recall, I don't know, it's probably about 10 years ago, arbitration became a very big deal, seen as a vehicle for potentially avoiding wage and hour class action. It's been very effective for that purpose, and we'll talk about that real quick when we get into this section of the program. But to Caroline's point about the various expansions of the employment discrimination laws and regulations that she just went over, and where we see that going, arbitration may become a popular topic again going forward. So let's go to the next slide. Okay, so just briefly as a refresher, the Federal Arbitration Act establishes a strong public policy favoring arbitration of disputes. And as noted, the significant advantage of arbitration agreements has been to forestall the substantial initiatives on the plaintiffs at the plaintiffs' bar to bring wage and hour class actions. So these arbitration agreements usually include collective and class action waivers that bar proceedings on a class-wide basis, and they've been very, very effective for that purpose. And the waiver can, of course, apply to other claims as well. But the significant increase in wage and hour litigation is basically what prompted the attraction and appeal of arbitration agreements. And a number of companies, probably some of you as well, have adopted them. Let's go to the next slide. By the way, I apologize. There does seem to be some issue with my microphone. I'm trying to get closer to it, and hopefully that will resolve the problem. So over the past few years, in response to the significant proliferation of arbitration agreements, especially among larger employers, some states have tried to enact legislation that limit the use of such agreements, at least for pre-dispute arbitration agreements. So New York was probably at the forefront of this, and you probably read about a lot of the cases. Really, the Harvey Weinstein situation was a significant event fueling this sort of legislation in New York that prohibited arbitration agreements or pre-dispute arbitration agreements outside the collective bargaining context for certain types of claims, specifically claims alleging sexual harassment. So there was a lot written about the privacy of the process, the fact that these sort of claims can be theoretically swept under the rug in private proceedings, and allow the problem to persist, the problem of sexual harassment in the workplace to persist, because it was not, the public was not being alerted to what was going on. So New York, a couple of years ago, eliminated arbitration, mandatory pre-dispute arbitration in the context of sexual harassment claims. However, the Federal Arbitration Act has a very strong preemption provision that the Supreme Court has time and again struck down state laws that essentially discriminate against arbitration, that treat arbitration agreements different than other contracts, as being inconsistent with the letter and spirit of the Federal Arbitration Act. And New York's law has been deemed by at least 3 or 4 federal courts in New York and the Southern District of New York as being preempted by the Federal Arbitration Act. In fact, I just read about another decision that was handed down this week reaching that same conclusion, and therefore allowing these cases to go to arbitration, notwithstanding that they would otherwise be barred by the New York statute. There is one state court decision in New York that holds otherwise, and where the court concluded that the ban on arbitration in New York, the limited ban on arbitration in New York, is not preempted by the FAA, by the Federal Arbitration Act, and therefore is effective. That case is on appeal. I suspect ultimately that ruling will be reversed at some level, given the numerous Supreme Court cases that support the conclusion of the district court decisions that we've seen out of the Southern District. Let's go to the next slide. Okay, and in 2019, kind of an interesting development in New Jersey under the law against discrimination there, which is their Title VII/ADA equivalent. The legislature enacted an amendment to the LAD, the law against discrimination, That doesn't say anything about arbitration, but it makes unenforceable provisions in employment contracts that waive any substantive or procedural right or remedy relating to a claim of discrimination, retaliation, or harassment. And plaintiffs' lawyers have argued that the purpose of this provision, or the effect of it, is to bar pre-dispute arbitration agreements as they apply to LAD claims. We actually dealt with that issue in a case in New Jersey. We briefed the issue fully, both arguing that the provision doesn't actually say anything about arbitration or bar arbitration agreements, and if it did, it would be preempted by the FAA. We had an interesting oral argument with the judge, and before we got a ruling, the plaintiff's lawyer pulled the case and essentially conceded and took the case to arbitration. So we never got a determination, and I don't believe there's been a judicial determination as to the impact of this amendment to the LAD. There have been two significant arbitration decisions issued in the past 6 months or so by the New Jersey Supreme Court about arbitration, and they're pro-arbitration decisions, but the cases arose prior to the 2019 amendment, so the court had no occasion to consider the FAA preemption issue or the meaning of this particular amendment. But keep an eye out for that in New Jersey if you have operations and cases there and you have arbitration agreements. Next slide. Okay, so another legislative development on the federal level, the Forced Arbitration and Justice Act would have a significant impact on arbitration, because obviously it would apply nationwide and not just to individual states. It would limit compulsory arbitration in a whole host of settings, including in the employment area. President Biden seems to be in favor of this sort of legislation. Congress just heard some testimony, including from the former Fox News host Gretchen Carlson, who was one of those folks who had a sexual harassment, sexual discrimination claim predicated on conduct attributed to Harvey Weinstein and the whole situation at Fox News, which I'm sure everybody has read about or seen the movie Bombshell. I think it's called Bombshell, but in any event, she had some impassioned testimony in Congress, speaking, primarily to the fact that arbitration is a private setting, as distinguished from court, where there is a public forum to air these sort of grievances and bring the situation of particular allegations and concerns to the attention of the community. To me, it's a little bit of a false argument, because there's typically nothing preventing somebody from talking about a case to the media if the media has any interest in it, even if it's an arbitration. The only significant difference is that the pleadings and the like is not on a public docket. And then perhaps the most important difference is the trial is not public. The hearing is not public. You can't just walk in and sit in an arbitration hearing like you can with a trial. And that's been a big pitch that Gretchen Carlson and others of the same mindset have been making and did make to Congress. This, in the current environment, this strikes me as an issue that is going to get backburnered. It certainly doesn't take on the importance of the stimulus package and various other issues that seem to be at the forefront, like immigration, infrastructure, and the like, where the administration and Congress will undoubtedly be dedicating more attention. But keep an eye on this, because it does have presidential support and would be a game changer so far as arbitration agreements are concerned. Next slide. So just if you have an arbitration agreement in place, it's probably working for you. Don't want to spend too much time on this, but just sort of things to think about if you're contemplating, in light of the developments that we foresee, as Caroline described, maybe going the arbitration route with your workforce. There are a lot of positive aspects to it. The most important one, I think, is the elimination through a class action waiver of potential class and collective claims for discrimination in wage and hour claims and the like. The lack of a public hearing, which does make it more private. Some say it's less costly. I'm not so sure about that. Arbitration is a pretty comprehensive process these days with pretty extensive discovery, and you're paying an arbitrator, excuse me. So it can actually end up being, more expensive depending on how the case is litigated. But on the whole, most folks consider it to be better than the alternative, which is court litigation. There are cons, however, so let's go to the next slide. Okay. One of the biggest cons is, although there's an internal procedure at the primary arbitration agencies, JAMS and AAA, for judicial review, it's very much in its infancy, and there's a great deal of uncertainty as to how effective it is as a means of trying to reverse an unfavorable arbitration decision. I suspect it won't be a useful tool in many or any cases. In order to have an effective agreement, the company has to pay the arbitration costs, which can be tens of thousands of dollars. If you take a case to a hearing with a JAMS or AAA arbitrator, you're probably looking at arbitrator fees and administration fees. It could be $40,000, $50,000, $60,000 on top of your legal fees. So it can be expensive. Arbitration tends to be a little bit of a crapshoot. You don't have the same type of evidentiary rules. It's a lot more Wild West. In that sense, sometimes these cases can drag on. Quite frankly, arbitrators have a financial incentive to keep the case going. And for that reason, even though there's a process for dispositive summary judgment motions, it's highly unlikely you'll get rid of a case short of a hearing. It's not in the arbitrator's financial interest to do so. So just some things to think about in that regard. Next slide.
Larry, can I just jump in here for 2 seconds? There's another thing that we've been experiencing, and that is arbitration is getting to be almost as expensive as court litigation. There's discovery motions. There are, we've had arbitrators allow depositions. And so it's getting to be very trial-like. And depending on whether you have a panel of 1 or 3, it could get just as expensive. And a panel of 1, you only have to convince 1 person, and the other side only has to convince 1 person. So we tend to gravitate toward more than 1. And then again, that becomes pretty expensive. So some of our clients have actually decided they're better off in court than in these arbitration settings.
Good point, Mary. We've definitely seen some pullback from arbitration, but I think it's still very, very, very popular. Again, primarily because of the ability to get out from underneath potential class actions. So let's shift gears and talk about an issue that I know we've been getting a lot of questions about now that the vaccine has been approved, at least on an emergency use basis. We now have a 3rd provider in Johnson & Johnson. There's been a significant ramp up in the rollout of the vaccinations, and it appears that most people will be able to get vaccinated within the next 3 or 4 months by all indications. So a lot of companies are inquiring about policies that relate to vaccinating employees, and what, if anything, employers should do to facilitate vaccination on a wide scale among the workforce. So let's go to the next slide. Okay, there's no particular OSHA guidance on this. OSHA certainly doesn't require employers to mandate vaccinations. OSHA did issue some guidance recently. I'm going to leave that for Mike Miller to talk about in detail. But the guidance is really dedicated to protocols in maintaining a safe workplace. There's no reason to suspect that OSHA will step into the breach here and issues any sort of mandates as it relates to vaccines. So let's go to the next slide. What policies have employers either implemented or are under consideration? There's a mandatory vaccination policy that an employer can mandate vaccines. The EEOC has indicated that there's nothing unlawful about that if that's the direction you want to go. There's something of a middle ground requiring employees who are going to be in the office to be vaccinated. A prominent law firm on the West Coast has taken that approach. Of course, a law office is one of those types of industries where remote working is possible. All of us on the panel today have been doing it for months. In a lot of other environments, remote working is either impossible or difficult. So such a policy may not be useful in that context. Some employers are encouraging vaccination through either an education campaign and/or incentives that Caroline alluded to, and we'll get into just briefly a little bit in a little bit more detail. And then there's always the option of no policy at all. Just leave it to your employees to decide what they prefer to do and how they prefer to deal with the issue. Obviously, this is kind of a personal question about whether to get vaccinated, and if so, when. Next slide. A couple of law firms, labor employment law firms, national firms, have done some surveying of employers. And these were done a couple of weeks ago. But they did have a significant number of respondents, up around 2,000. So it's not a bad survey in terms of giving you some indication of what companies are planning to do. And the surveys, as I understand them, were across the spectrum, a whole wide range of industries. They weren't limited to one or two. So you've got a pretty good sample size from what I could see in terms of what was published about these surveys. And what the surveys revealed collectively is that very few companies right now are considering mandating vaccines. As you can see from the first bullet point there, right now only 1% have mandatory vaccination policies, and only 6% are even planning to do so. And a lot of them are uncertain as to what they're going to do in that regard. 64%, though, have no intention of implementing a mandatory vaccination policy.
Larry, we have a question. Does OSHA's general duty clause come into play? Unless we need to leave that to Mr. Miller.
Yeah, I will let Mike answer that question. My thinking is no, not as to vaccines per se. In regard to safety protocols to try and avoid an outbreak in your workplace, the general duty clause may well come into play there. And I think Mike is up next, so he's our OSHA guru, and we'll be talking about issues like that in the next segment. But that's my understanding.
Thank you.
Tell me if I'm wrong for sure. Again, just in terms of the survey, you can see on the screen what is going on in terms of industries. I guess the one that I was a little bit surprised about is that only 12% of healthcare employers are in the mode of perhaps mandating vaccination for their employees. So that's pretty interesting to me. It's a good indication of how reluctant companies are to impose that sort of requirement on the workforce. Next slide.
I can tell you, Larry, that some of our healthcare clients who we work with have indicated part of the reason they're not doing that, at least not yet, is twofold. Most of their workers are volunteering to do it anyway. And second, until we are assured there are sufficient vaccines for everyone, they are hesitant to mandate it.
Yeah, and to sort of follow up directly from there into the next slide, I think there is a general receptiveness to getting the vaccine. So, policies may not really come into play all that much, but a lot of companies are considering incentives to push people who might be a little bit hesitant across the line to get vaccinated. And the slide shows what the survey reflects in terms of what type of incentives folks are considering. Cash is king, I think. So 46% are considering some sort of cash option, but half of the surveyed companies like the idea of incentives, but aren't entirely clear on what they want to do in terms of specifics. Next slide, please. Just some examples.
Larry, I'm sorry, I was muted. We have a question apropos of what you were just talking about. Is there any issue with companies who do have special COVID benefits to restrict those if the employee does not take the vaccine, assuming no underlying vaccine reactions? So I think the question is, for those that are giving incentive, well, it says COVID benefits, to restrict them if somebody will not take the vaccine.
It sounds like you're talking about disincentives, so using the stick instead of the carrot.
I think so. I'm just reading the question, and if the questioner would like to send some clarification, otherwise just, go ahead.
Yeah, I mean, I haven't seen that. I haven't seen any clients of ours, or from what I've read, of folks using the stick instead of the carrot.
He says yes, the stick. He's asking about the stick.
I guess it'll largely depend on what kind of benefits you're talking about. So I don't know if there's PTO days that have been provided, or what it might be. So that's probably something that's a good discussion for offline or a follow-up. We can get some more details and get into the weeds on that. But that's a very interesting question. I have not seen disincentives as part of the equation. What we have seen are these sort of monetary incentives. The highest I've seen is $500. Most are less than that. PTO is a very popular option, giving people time off to get vaccinated, or just providing them with a day or some hours of pay as a quote unquote reward for getting vaccinated. Next slide.
Larry?
Yeah.
So one of the questioners had the follow-up asking about enhanced time off like PTO, and it sounds like what we're saying is, yes, some companies are doing that, and the EEOC has yet to weigh in as to whether or not some of these incentives are problematic. And another question, which I think ties into that, is about wellness incentives and what employers can offer. And you were talking about this at the beginning, and this questioner missed some of it. But if you could repeat what you were mentioning about wellness incentives in general and how they play into this, I think that would be helpful to the audience.
Yeah, and I think somebody's ahead of us by a couple of slides. So I think we're going to get to that. Frankly, there's not a whole lot of guidance right now, because I think Caroline mentioned there was wellness guidance in the EEOC that was actually withdrawn. So we're in more of a vacuum than we were before on this. But I will touch on it in a second and let you know what we do know, which quite frankly isn't all that much. In terms of the legal implications, as I mentioned, a vaccine mandate is not per se illegal. The issue really comes into play when you have folks who have some sort of medical condition that precludes them from taking the vaccine or makes it unsafe. Then you get into a reasonable accommodation scenario where you have to explore accommodations for those folks. Same thing with folks who have a sincerely held religious belief that with disabilities, you can, of course, ask for medical documentation if you're so inclined. Most employers don't. If somebody says they can't get vaccinated because of a medical condition, the employer usually accepts that at face value. Sincerely held religious beliefs are a little bit difficult to probe and awkward to probe. I think most employers generally take those at face value as well and move into the accommodation mode on that. Next slide.
Larry, we have a question. Is it legal for employers to ask employees to voluntarily let them know that they were vaccinated? Reporting only, not requiring proof.
Yeah, that's perfectly fine. I don't see any issue with that. I don't know if you do. I don't see a problem with that. I don't see a problem with asking for proof, especially in certain environments where employees are going to be in close proximity to one another. So I don't see an issue there. In terms of ADA accommodations, this will come up from time to time. What type of accommodations can you make for employees who can't get vaccinated? Telecommuting might be an option. Otherwise, it's what you've been doing, probably strict masking and distancing requirements. Maybe there's a private office or a remote workspace that you can move somebody to. The key here is just to be flexible. What's appropriate will vary from workplace to workplace. So you need to figure out what works for you and what works for the individual employee. Meeting is an option. That's probably the best way to go for someone who's not vaccinated, at least at this juncture, well before we've reached the stage of herd immunity. Next slide. Potential claims under a vaccine mandate policy, for folks who refuse. You have accommodation issues under the ADA and Title VII if applicable. In theory, someone can claim they were wrongfully discharged under one statute or another. Under a common law, I don't see much heft to those sort of claims. Frankly, public policy implications favor vaccination. So I don't think if someone refuses to abide by a mandatory vaccination policy without ADA or religious-based reason for doing so, I think an employer with that policy would be well within their rights to terminate the employment relationship or take some other adverse employment measure. Keep an eye, I guess, one theoretical possibility is a disparate impact claim. If refusal to vaccinate is more prominent among a particular group, protected group, and you enforce such a policy, might there be a disparate impact? Seems like kind of a remote possibility. Workers' compensation can come into play in this scenario. If somebody claims they've contracted the virus at work, or, and frankly, in Connecticut, adopted a presumption that if you were working on site and did contract the virus, that it was work-related, and you'd be entitled to workers' compensation benefits. That's not the basis for a tort claim. That would be a workers' compensation claim, as would a claim that you missed time due to side effects associated with the vaccine. There was actually a case in California that I read about just yesterday where the spouse of an employee brought a case against the employer. The employee had contracted the virus ostensibly in the workplace, brought it home, and his wife also got sick. She brought a claim against the employer in tort, and the court said, nope, that's a workers' comp claim too, even for the non-employee. So workers' comp exclusivity is a pretty expansive concept, and a good thing in this setting, obviously, because that's covered by insurance. Next slide. So just quickly, what are the benefits of a mandatory vaccination policy? As I said, most employers are not going this route, but there are some benefits to it. It's likely to maximize the vaccination rate in your workplace. In terms of patrons and other employees, knowing everybody's been vaccinated will probably provide some comfort. People are less likely to get ill and miss time, and so you have higher, lower rates of absenteeism and higher rates of productivity. The potential for a widespread outbreak is reduced, something that might shut down your workplace. To the extent you are subject to a claim, somebody who alleges that they contracted the virus in your setting, a patron, for example, an invitee, somebody who comes into the workplace, that's a negligence claim, basically. With an employee, obviously, it's a workers' comp claim. But if it's a negligence claim, you certainly have a better defense against that if you took all the precautionary measures, and mandatory vaccine might be one of them. Next slide. The downsides, I think people just tend to react badly to being told what to do, especially when it comes to matters of personal health. People don't want to be told that they have to take a vaccine. That could be morale issues associated with that. If you have a mandatory vaccine policy, are you going to end up with folks making suspect claims that they have a disabling condition or a sincerely held religious belief, that then you get into these awkward conversations, probing the veracity of those contentions? It's not really a great place to be. And, frankly, you have to enforce it. Are you going to make exceptions outside the ADA accommodation or Title VII accommodation setting? Are you going to be rigid about your policy? If you're not going to be rigid, you might want to think that there's another way to go, perhaps with encouragement, incentive. So let's go to the next slide.
Larry, we had a question which, given the interest of time, I took the liberty of answering, so I'll just tell the audience that the question was pointing out where healthcare organizations have already required flu shots and special PPE even pre-COVID. Can a policy be developed where it's an or proposition? You have to get vaccinated or you have to wear PPE. And I answered that we don't see any prohibition against the or, given you can mandate vaccines to begin with. We don't see a problem.
Yeah, I agree with that. Absolutely. The good news there is there's some meaningful flexibility here in how you want to deal with this in a way that's best for your particular work environment. So, one of the other options we talked about, and a lot of companies are doing this, or at least thinking about doing this, is using some sort of incentives. Maybe a better option than a mandate for a variety of reasons, including avoiding these sticky accommodation issues. and potentially, suspicious claims of a disability-based or religious-based objection to being vaccinated. Next slide. Okay. There's some downsides to it. You're probably not going to get as high of a vaccination rate, and the implications of that as detailed on the bullet points. Next slide. Okay. And I think Caroline may have alluded to this. With incentives, if an employee cannot be vaccinated, let's say because of a disability, they're not eligible for the incentive. And this is the wellness program type issue that we talked about, where there's a real vacuum in terms of guidance. So employers are questioning, well, how much can I provide in the form of an incentive without creating a significant disadvantage to employees who are protected by the ADA? And the answer is we really don't know. As I said, the most significant thing of value I saw was a $500 bonus that a hospital group in Texas was offering, which is pretty significant incentive. About 2-3 weeks ago, the Chamber of Commerce, along with 40 other business groups, asked the EEOC for guidance on this very issue about how far can we go with incentives. So far, we've not seen a response. However, I think Commissioner Burroughs and the other commissioners at the EEOC are very, very attentive to the COVID issues and have been very assertive about putting out guidance. You'll recall there's been a great deal of guidance already issued with the legislation that went into effect last year in terms of the CARES Act and the like, and very useful guidance, by the way. So I think they will respond to this with something. It's just a matter of how quickly they can do it and how detailed and specific it will be. I think it's something they can do effectively, and it's just a matter of really timing. The sooner the better on this, but keep an eye out for that, because that will really give you a good sense of what you can and can't do. In the meantime, it's probably best to use less valued, modest incentives as opposed to significant cash payments and the like in terms of providing incentives. That would be the safest way to go. I think the likelihood of these sort of claims are pretty remote, but in terms of strict compliance, I think the safest way to go is providing PTO of a couple hours to get the vaccine or something along those lines, or an extra PTO day, as opposed to significant cash incentives. Next slide. Okay. Just a reminder, most companies are using third-party providers, whether they have a policy of encouraging or mandating vaccines. There's good reasons for that. Convenience. You don't have the implications under the ADA or the Genetic Information Non-Discrimination Act, because if you're getting a vaccine, the person giving the vaccine is going to have to ask certain medical questions. You want to take that out of your workplace. If you do it, there are implications under the statute. If CVS does it, there's not. And I think that's what most folks are doing anyway. I'm going to say next slide, but I think that's the last one. So let's just go to the next one and see what's there. I'm sorry. Just some things to think about. At this point, now that the vaccines are being rolled out at a more rapid rate, if you haven't done this already, you might want to think about putting together a committee to deal with these issues, establish policies and protocols for vaccinations, be available to answer employees' questions and the like. Set up rules for what you're going to do if folks are absent, either getting the vaccine or because of side effects, and implementing or probably continuing to implement safety protocols and monitoring all the guidance that's being issued. It would be good to have a team of people with an HR rep, legal if you have a legal department, other folks who are progressive thinkers and folks who are considered to be trustworthy and reliable and well regarded within the workforce to deal with the issues and the sensitive discussions that are likely to follow as a result of the vaccine situation. Now I think we're going to hit the last slide. Let's go to the next one and see what we got. There we go. Okay. So I had mentioned OSHA. I'm going to turn it over to Mike, and he's going to give you a little insight on the OSHA implications of what's going on with far more capability than I could. So thanks, Mike.
Thanks, Larry. Good morning, everybody. My name is Mike Miller. I'm an environmental and health and safety lawyer, resident in the New Haven office. I work with a whole host of industry, healthcare, manufacturing, services, retail, and over the past year, we've really had some significant and meaningful experience counseling companies on how to stay open safely, interactions with Osha with respect to employee complaints and investigations that have arisen during the pandemic. And I'm just gonna, in kind of broad strokes, give you some of those, share with you some of those experiences, but also provide some updates that we expect by way of the Biden administration's implementation of COVID rules. So we'll start with the first slide, please. So the past year and leading up to the election, the Trump administration, OSHA under the Trump administration really relied on guidance, publications, FAQs. This is really a field of regulating by guidance, which for lawyers and regulated entities is a bit of a nightmare. That means that, you know, rules and standards are not going through formal notice and public comment, stakeholder input, et cetera. So back in March, and then it was reiterated over the summer, the agency issued guidance on preparing workplaces for, you know, COVID-19 response. It included a bit of kind of general protocols that you would expect in a safety plan. However, I think most important was a risk priority matrix, really a hierarchy about how to assess the risks your employees may encounter by way of the pandemic. Is the exposure to the general public frequent? Are they in the healthcare or first responder fields where the likelihood is much greater that they have a meaningful exposure to COVID? And then based on that threshold ranking, the agency expects the employers to devise, you know, safety plans, physical distancing barriers. Now masks or face coverings are typically required everywhere now, as we know. But OSHA came out and said that's not PPE as we define personal protective equipment in the OSHA standards. PPE is specifically designed to address a workplace hazard, like a respirator, for example, in a chemical fume environment. So that interpretation has not changed. However, there's PPE required in certain, like healthcare industries and first responder industries, face shields, or, you know, something greater than just a cloth face covering. So that is something that came out of the agency during the Trump administration last year. There was also a lot of focus on illness reporting and recording, right? So unpacking that a bit, Caroline Park and I worked with several clients to understand, do you have an actual recordable workplace injury or illness by way of COVID exposure if your employees catch COVID or test positive for COVID? And there was guidance issued in March and then reissued later in the summer, and then in further interpretation, clarification guidance in the fall. And really the guidance was all over the lot. But employers are expected to make a workplace relatedness determination with respect to employees who provide, you know, evidence that they've tested positive. And that's not the crux of this presentation. That's really a more detailed analysis. And we're happy to get into that on a case-by-case basis because it is so fact specific. But I wanted to tee up that was a major issue last year that employers faced. Fast forward to President Biden taking office and his January 21st executive order kind of reiterated the previous standard, we'll call it, that was enshrined in the Trump OSHA's administration. Things like the measures to address hazards in the workplace presented by COVID, physical distancing and barriers, and reporting and recording. President Biden also directed the agency, to the extent that they're planning to issue an emergency temporary standard, ETS, that those plans are made public by March 15th of this year. To me, that really signals that there's a rule coming out. There is no specific COVID standard. It's all been regulation by guidance, taking other standards that loosely provide a framework like bloodborne pathogens and other standards, respiratory protection, PPE. But we really do expect that the agency will issue a COVID standard sometime this year. And I think what we can do is we can look to state plan states, and those are states, not Connecticut, but states like Virginia, California, Michigan, who have delegated authority under the Osha Act to establish their own health and safety program. They are the enforcement body under the Osha Act. They have to, at a minimum, meet the federal requirements, but they're free to impose additional safety requirements, more stringent safety requirements on regulated industry. California and Michigan standards, when we've looked at them for other clients, are pretty onerous, and there's some problematic provisions in there about notification and when you have an outbreak, which is 3 or more cases clustered. I guess if I had a crystal ball, I'll never know what's going to happen this year, but I would expect the agency at a federal level to mirror something more like the Virginia standard, which largely, in my opinion, enshrines that previous guidance that was rolled out. It addresses and likely will address things like having a written COVID-19 response plan, doing that written hazard assessment for all the tasks that your employees are encountering during the workday, doing whether or not personal protective equipment or something else is required, and employee training, I think, is going to be very important. I also expect increased enforcement this year. Largely, I think, not to begrudge what the agency's agenda was last year, I think they were very reactive. They opened a lot of cases based on employee complaints. People were scared to go back to work, and they were calling OSHA for assistance. So we worked with a lot of employers to respond to letters for information and document requests, et cetera. Interestingly, at the beginning and through the summer of the pandemic, OSHA wasn't doing on-site inspections unless it rose to a certain level of severity, in their opinion. So most of this was, papering back and forth and responding. But the legal basis upon which, in the absence of a specific standard, that OSHA was acting under its enforcement authority is, as a participant indicated before, the general duty clause, where employers are expected to provide a workplace without unreasonable hazards to its employees. I've not yet, there have been allegations in certain cases, and we'll get into those, allegations that there were general duty clause violations, particularly in the nursing home space and hospital space. There were also enforcement cases relating to those healthcare entities in particular for failure to report hospitalizations within 8 hours that were deemed to be work-related COVID exposures. But those were really the kind of major volume of enforcement actions and citations that the agency pursued last year. We expect increased on-site inspections, and again, to the extent that emergency temporary standard is promulgated, we would expect increased enforcement. Let's go to the next slide. So in addition to the general practices that Biden's executive order identified, we wanted to point out that there's a renewed commitment to whistleblower protections. There was, much like just calling up and alleging an OSHA hazard, which any employee can do, there was also a surge in OSHA whistleblower complaints or charges. You may know this, you may not. OSHA is the federal agency that's delegated to investigate whistleblower complaints with regard to not only safety violations, but a whole host of federal statutes. And so they've opened based on what we found, approximately 30% more whistleblower charges. And those were specifically just alleging workplace safety retaliation. So I think what's really important is that, and we worked on a couple of these last year, that one was successfully dismissed summarily. Very important for employers, supervisor level, management level to understand that to the extent there's an adverse employment action taken, is it documented that, this is not being taken with respect to a protected activity, like alleging a safety concern or a health concern. I leave it to very fact-specific analysis as to what that means. But having some, investing some time to enhance training of your supervisors and management on this particular issue could be very beneficial to organizations, particularly when we see such a rise in whistleblower charges over the last year. Next slide. So this, you probably can't even read this graphic, but the x-axis is February 2020 through January 2021, right? So you're seeing COVID outreach activities from the agency, but also COVID closure case activities on the rise. In my experience, the OSHA cases that were opened, requests for information, largely were closed very quickly. The clients that we work with had documented policies. They were really attempting to do what they could in accordance with guidance, and the agency gave them credit for that and reached back out to the complainant or the employee who raised the concern. So I just wanted to bring this graphic up. This is consistent with our experience. Mary, was there a question?
Mike, yes, we have a question. So the OSHA standard for reporting a hospitalization is that you must report it within 24 hours of the injury or illness, and subsequently report it within 24 hours of learning of it. Since COVID-19 is not transmitted immediately and does not create severe disease within 24 hours of exposure, how are they citing that standard? Employee hospitalizations could be well over 24 hours of their work exposure.
Yeah, and the hospitalization could be a week after the exposure, right? So what we advise clients is you have to investigate the work-relatedness determination first. Once the employer is reasonably made aware that an employee has tested positive for COVID, go through your contact tracing protocols. Are you finding clusters? Is it more likely than not that the exposure to COVID for this employee occurred in the workplace? Document all of that investigation to determine whether or not it's workplace related, right? If it is a workplace related illness, then you go into that time frame. And really the 24-hour time frame in our experience has been interpreted by the agency over the last year as 24 hours within the time period, from the time period the employer became aware of the hospitalization. So you do have a very quick turnaround to do that work-relatedness determination. In other instances, where the employee is at your work site, they're taken away in an ambulance, maybe there's a cardiac arrest or some other illness or injury, that 24 hours is really intended to, there's a presumption that it's work-related when it happens at your facility. So there's even a standard for those types of injuries and illnesses where it's 24 hours from when the employer reasonably should have known of the hospitalization. So there's a lot of challenges in satisfying this reporting obligation. You don't often have direct line of communication with the employee when they're admitted for hospitalization. Their family members who you do have contact with may not be entirely forthcoming about whether or not they are in fact admitted or just being seen or observed. So these are very specific factual determinations, and we've worked on many of these cases over the last year. So if there are further questions, I'm happy to handle them individually. All right, next slide.
One quick follow-up. Hospitalization means admitted to the hospital, correct? Not an ER visit.
Correct. All right. OSHA COVID enforcement. I'm sure you all heard over the summer there were suits brought against the meatpacking industry, Smithfield in general, alleging the company's failure to protect employees. They were alleging that there were outbreaks in their Midwest facilities. It got through federal court. The actions were filed in federal court, and the judge dismissed the claims on jurisdictional grounds, claiming that OSHA had already opened an investigation, that the claims were preempted by the Osha Act, which is federal law. And then, I just wanted to highlight, there's a recent case in New York. The New York Attorney General is now suing Amazon over that company's failure to provide proper pandemic health and safety measures. Interesting, against the backdrop of a federal judge dismissing the Smithfield claims on preemption grounds, what will happen with this suit, whether or not it's brought under, some sort of New York law, if they're alleging or claiming violations of perhaps a state executive order as the basis. We haven't really dug into it, but the facts are, as alleged, pretty damning. 250 employees at the Staten Island facility were reportedly had notified the company of their positive COVID status. More than 90 of those employees were on site within 7 days of that notification, and in more than 80 instances, Amazon didn't close any portion of the facility. At least those are the allegations as pled. We'll see how this one plays out. But certainly it signals, the do nothing approach, which it's very rare for employers to do nothing as alleged, could have very drastic circumstances. Okay, next slide, please. There's been a development in repeat violations and how the agency evaluates these, right? So the test is really for a repeat violation. The agency has the authority to allege a 10 times multiplier to its maximum penalty. The 2021 inflation rules provide the penalty authority to the agency to be $13,653 per serious violation. Using that 10 times multiplier, a willful violation or a repeat violation has a maximum penalty assessment of $136,532. There was a recent 10th Circuit Court of Appeals decision upholding OSHREC, which is the Occupational Safety and Health Review Commission's decision, that following an acquisition, there was not substantial continuity between the two entities, the acquirer and the seller entity, to allege the repeat violation. In that instance, there was a previous violation cited by the seller entity with respect to a boiler explosion and the facts and circumstances leading up to it. Fast forward, you have the acquiring entity who thereafter, after the closing, changed leadership. Those leaders hired new safety management, started to make different safety management decisions and policies. And the OSHREC at the agency level determined that there was not sufficient continuity between the safety management decision makers, the policies of the company, et cetera, to allege and really support a repeat violation, and the 10th Circuit recently affirmed that decision. The next slide really is just a summary of that case. It's the Wynwood refining case. But that's all I had. I know we're tight on time, so I'm going to wrap up there. And thanks for the opportunity to present to you folks.
All right, thanks a lot, Mike. Appreciate that. We are running a little bit behind. We would ordinarily do a break here. I think we're going to skip that to try and keep everybody on schedule and try and wrap this up at or around 10:30 if possible. I think we'll run a little past that. We will continue to try and answer your questions as they come up, but do feel free if either your question isn't answered or you have one that you've been holding for the end. We can answer some at the end. We'll stick around after the appointed time. And you can also just feel free to email any of us directly with your follow-up questions. We're happy to answer those for you after the webinar later today, tomorrow, whenever the spirit moves you. So let's roll over into what's going on, or what we envision going on at the National Labor Relations Board. Josh, you want to take it from here?
Sure. Thanks, Larry. So we're just going to talk briefly about recent developments at the NLRB and what to expect under the new administration. Next slide, please. Real quickly, we're going to talk really briefly about some personnel shakeups and how the new personnel who have been installed by the Biden administration have rescinded some Trump-era guidance, and then we will touch on what to expect from the Biden administration with respect to labor policy. Overall, the Biden administration's labor policy has two primary goals. The first is to promote collective bargaining and to encourage union membership. So not a huge surprise there for a Democratic president to be promoting those goals for labor policy. And so to accomplish those objectives, the administration is going to try to first dismantle Trump-era policies and then try to build things back with an aim toward what they perceive as more balance in the workplace. So next slide, please. So what's already happened? There's a relatively dramatic opening, a dramatic action at the NLRB from an agency we don't hear much about. Borrowing from the former guy, President Biden decided to fire the NLRB General Counsel Peter Robb. He did so. His administration did so 23 minutes after he was sworn in. So he did that while he was still on the dais. The notice went out to Robb. So you may have seen some of this in the press. They sent an ultimatum saying resign by 5 o'clock or you'll be fired. Robb refused, and he was fired. He was the first GC to be fired since 1950. Robb was seen as hostile to worker and union rights and was replaced by Peter Sung Orr, who used to be the regional director in Chicago. In his refusal letter, Robb explained that the removal of the general counsel would set an unfortunate precedent for labor relations in this country that will permanently undermine the structure and thus the proper function of the NLRB. He noted that the general counsel position was created to be independent of the NLRB and the executive branch, so the general counsel, as chief prosecutor of the NLRA, can prosecute potential violations of the NLRA free from political influence and pressure. This was an immediate, right out of the gate promise fulfilled by the Biden administration. This was not unexpected that he would want to get him out before he finished before the end of his term and later this year. Another, if we can go to the next slide, just to talk briefly about the board itself. Another move made by the Biden administration, by President Biden, removed Republican Chair John Ring of his chairmanship and installed the lone Democrat Lauren McFerrin as the new chair. That's largely symbolic, as you can see on the slide. There's still a 3-to-1 Republican majority. President Biden will be able to fill a vacant chair at some point this year, and then board member William Emanuel. William Emanuel. His seat expires on August 27th, 2021. So there will be, at that point, once we have the vacancy filled and Emanuel replaced, we'll have a 3-to-2 majority. Interestingly, a little development yesterday, Lauren McFerrin made a somewhat rare appearance at a virtual conference hosted by Cornell University. And she discussed labor policy, obviously. And she didn't really pull any punches in that discussion. And she said, if I had to characterize the impact of the Trump board in a nutshell, it would be to say that this board's work has made the act smaller, both in terms of its coverage and in terms of the scope of the activity that it protects. She said that obviously makes it harder to strike a balance of power in the workplace, and said that's exactly the wrong direction for the act to be moving in these perilous economic times. She also discussed her desire to reverse some Trump-era decisions, which we can discuss a little bit later if we have time. But she also expressed support for the Trump-era board's support and their push to move the decision-making process to rulemaking instead of through case law. She obviously does not agree with any of the rules that they issued, but she does like that sort of that procedure and format. So she thinks that we can expect that when she is chair of a Democrat-controlled board, that they will do more of a push toward rulemaking. Next slide, please. So right out of the gate, Peter Orr rescinded 10 guidance memos and 2 advice memos that were issued by Peter Robb. They largely relate to the revocations are largely relate to the administration's labor relations goals that we discussed on the prior slide, and this is really setting the table for the resumption of Democratic control of the board later this year. Next slide, please. So real quick, I'm not going to go through all of the memos that were rescinded, but the first one we'll talk about is a handbook rule. There was a rescinded guidance memo instructing regions on where to place the various types of employer rules in the categories that were set out in the board's decision in the Boeing company. Brief history on that, there were 3 categories set out. The category 1 was lawful work rules that do not reasonably interfere with protected rights or whose impact is outweighed by the rule's justifications. Category 2, rules that warrant individualized scrutiny. And then category 3, rules that are unlawful to maintain because they will prohibit NLRA protected conduct and the adverse impact on NLRA rights is not outweighed by justifications for the rule. Or rescinded that memo because he said it wasn't necessary to have a memo in light of the number of board decisions interpreting the Boeing case. We didn't need a memo on top of decisional law from the board. He also rescinded, with respect to whistleblowers, he also rescinded a Robb-era memo that raised concerns among NLRB staffers because it limited how the NLRB gathered evidence. That memo required the NLRB staff to tell whistleblowers that they could face federal charges or be disciplined by their employer if they gave the NLRB video or audio that they had obtained illegally. Or said, note that this memorandum is being rescinded because portions are inconsistent with prior practices. Regions should continue to not accept recordings that violate the Federal Wiretap Act or to apprise individuals who proffer recorded evidence when it may violate state law. But that was to sort of reverse the chilling effect that prior memo had. On motions to intervene quickly, the memo required regions to no longer oppose intervention in unfair labor practice hearings by proposed interveners who had filed decertification petitions or circulated documents upon which the employer unlawfully withdrew recognition. This would obviously seem to inconsistent with the idea of promoting balance in the workforce by allowing people who are anti-union to intervene and try to undercut an unfair labor practice. With respect to neutrality, real quick, a neutrality agreement is a contract in which the employer agrees to remain neutral in any organizing efforts by a union. But neutrality agreements often lead toward employer support of the organizing effort by providing the union with employee contact info, allowing employee union organizers access to company property, voluntarily recognize the union as employees' representative once a majority sign on union authorization cards, and more. So Robb's memo argued that many of these provisions provide an unlawful amount of support to unions in violation of federal labor law, and the memo argued that the easier to apply more than ministerial aid standard should be applied, and stated that the above mentioned provisions that I just talked about would run afoul of the standard if it was included in a neutrality agreement with the union. So the rescission of that now means that employers, that the regions will permit this employer support. And then there's also some impact on duty of fair representation claims. In the interest of time, I'm actually going to move on, unless we have any questions. No. Okay. Next slide, please. So what to expect next? The Protecting the Right to Organize Act, or the PRO Act. This was reintroduced by House Democrats earlier this month. This represents a massive expansion of employee rights in connection with essentially 3 buckets: the right to organize, collective bargaining, and unfair labor practices. For protected activities, the proposal, the act will expand and revise the NLRA's definition of employee, supervisor, and employer to broaden the NLRA's coverage. It'll prohibit employers from permanently replacing strikers. It will prohibit offensive lockouts. It will make employee misclassification an unfair labor practice. It'll remove limits on secondary picketing and strikes. It'll prohibit employer captive audience meetings. It'll require employers to maintain existing employment terms and conditions pending an agreement with the union, and prohibit employers from withdrawing union recognition without a decertification election. With respect to collective bargaining, second bucket, for initial collective bargaining agreements, the bill would require the employer to begin bargaining within 10 days after the union submits a written request. So it'll allow either party to request mediation with the Federal Mediation Conciliation Service if the parties haven't negotiated a contract within 90 days. It'll authorize the FMCS to refer the matter to a 3-person arbitration panel with the authority to bind the parties if the parties fail to reach an agreement within 30 days after mediation is requested. It'll also bar employers from requiring employees to waive their right to press work-related litigation jointly, collectively, or as a class. And to ensure fairness, the union representation elections under this bill would prohibit employers from gerrymandering a bargaining unit to include individuals who have no interest in joining the union. It'll permit petitioning employees to choose whether the election will be conducted electronically by certified mail or at another location apart from the employer's premises. It'll require the NLRB to issue a bargaining order if the union loses a representation election due to employer interference, and codify the NLRB's long-standing recognition bar, successor bar, remedial bargaining unit bar, contract bar, and blocking charge doctrines. Really quickly, with respect to unfair labor practices, to prevent unfair labor practice charges, the bill would authorize the NLRB to award back pay, front pay, consequential damages, liquidated damages equal to twice the damages awarded to employees, including undocumented aliens who have been discharged or have suffered serious economic harm in violation of the NLRA. It'll protect the right to strike. The bill would amend the NLRA to make clear that the duration, scope, frequency, or intermittence of any strike or strikes will not render them unlawful. And it allow employers and labor organizations to finesse the state right to work laws. The bill would authorize labor and management to agree to require bargaining unit employees who are not union members to pay a fair share fee to cover the cost of collective bargaining and contract administration. Getting rid of right to work laws is a Biden goal. He has a limited ability to do that because they're state laws, but this would go a little way that way. Odds of passage. I don't think this is a bill that's going to be able to be included or rolled into budget reconciliation. And I think absent eliminating the filibuster, this is unlikely to make much headway as drafted, or the House version is unlikely to make much headway in the Senate. But we've got 4 years. Let's go to the next slide. So some decisions are being targeted for reversal. The first is Caesars Entertainment. This Trump-era rule overturned a decision called Purple Communications, and that held that employees do not generally have a protected right to use their employer's email systems for the purposes of organizing union organizing activity, sorry. And then the Boeing Company, this has a rule that we discussed earlier with respect to handbooks. We're looking to overturn that. And then Johnson Controls, that's another decision from the Trump era, which upheld the employer's right within 90 days of labor contract expiration to suspend bargaining, withdraw recognition from the incumbent union based on objective evidence that the union no longer had majority support. Another decision they might look to overturn is PCC Structurals, which overturned the Obama era board's micro unit decision in specialty healthcare. Specialty healthcare made it easier for unions to organize really small bargaining units. So that may rear its head again as well. Next slide, next and final slide. Again, as I mentioned earlier, we can look for them to try to erode the impact of state right to work laws. President Biden made a promise to establish a cabinet level working group within the first 100 days in office. That group would be tasked with delivering a plan to dramatically increase union density and address economic inequality. So we'll see whether or not we're able to get that group together in the first 100 days with everything else going on. And then independent contractor organizing. As a candidate, Biden promised to extend the right to organize and bargain collectively to independent contractors, saying some workers are correctly classified as independent contractors, but are not very different from employees. So he supports modifying antitrust law and guaranteeing that independent contractors can organize and bargain collectively for their mutual protection and benefit. That's all I have. I will turn it over now to Naja.
Thank you. Next slide, please.
Hey, Naja, before you get started, there's a question in the chat. I think relates to your area of expertise more so than Josh's.
Yeah,
Okay,
I was just going to ask Naja to answer it. So when you have an opportune moment, Naja, the question is, if you discharge an undocumented worker, when you find out about it per ICE regulations, can you now be fined if that undocumented worker has adverse impact?
Okay, we will talk a little bit about this, and I will be happy to address fact-specific questions and case scenarios through the chat or afterwards.
Thank you.
All right. So in the area of immigration and compliance under the Biden administration, we are still watching for changes. Next slide, please. There has been a flurry of activity, but what we expect to happen is that I-9 employer enforcement will definitely continue. The directive will be less on penalty and surprises. We think it will be more compliance-related site visits to check up on things with advance notice possibly, and more on the audit front. We also expect an uptick in Social Security Administration no-match letters, especially after the quarterly tax filings. Here, we want to remind everyone that the Social Security Administration is not an enforcement agency, but employers are required to respond to those requests. We definitely work with clients on these, putting these together, as well as dealing with the audits and compliance activities that are scheduled. But for this, we want to emphasize that SSA shares data with Homeland Security, the IRS, Department of State, FBI, and so forth. And so enforcement can come if employers do not respond to these SSA no-match letters. We also expect employers to be mindful of all of the different travel bans that are continuing, especially in this day and age with international and remote workforces. The non-immigrant temporary visa bans and the immigrant visa bans we don't expect to continue. Those are immigration status specific. And in fact, Biden issued a directive yesterday to end the immigrant visa ban. So green card and permanent immigration items will continue processing and will be allowed to re-enter the US. The geographic bans are the ones that will continue, which are based on COVID protocols in specific regions. We expect a lot of policies and regulations to remain in flux because there were so many changes, especially in the last 2 years. There is ongoing litigation in pretty much every area. And so we advise that all of our clients sign up for our client alerts. There should be a lot going on in the next 12 months. And also for those of you that do sponsor H-1B workers in particular, there are a number of potential changes in litigation going. Some of it is to make the H-1B a little bit more costly. It is currently H-1B visa season. And for those of you that need more detailed guidance with that sponsorship, I am available to address that. And finally, we want to just alert everyone to the U.S. Citizenship Act of 2021, because if this goes through, which it's not expected to go through as an entire piece of immigration reform legislation, it's supposed to be expected to be broken down in pieces. But essentially, the Biden administration is trying to focus on providing an earned path to citizenship for individuals without status who have had status issues. It's looking to address more of the root causes of migration, to address some of the asylum and refugee issues and managing the southern border. And then it's looking to reform the immigration system for everyone. And this is really important for employers that have any type of not necessarily sponsored workers, but the fact that the eligibility and quotas that are annually impacted by green card supply and demand and visa supply and demand, if they increase or shift dramatically, there will be a flurry of activity with different status issues, and that will add to the compacted delay of COVID and already a Trump administration that was taking potentially 2 years or more to process cases. If there's a lot going on and a lot more demand and a lot more cases in the pipeline, with all of the citizenship agencies that are the USCIS, the DHS, all of the various agencies, they're working remotely as well. They are backlogged significantly. So this will have a trickle-down effect on things such as passports and licenses and other items that employees and employers need to maintain. Next slide, please.
Naja, we just have a quick question. If you could just elaborate briefly on what increased costs for employers refers to.
It's going to be, well, one, the penalties did get adjusted. They get adjusted every year. So penalties for non-compliance are also higher right now. We can provide that information later. But the other issue is time and effort. I always try to emphasize every year that I-9 compliance, especially any of these enforcement record items, they need to be addressed on an ongoing basis. But a lot of employers under COVID were confused with the guidance, and I will get into that in the next slide. They thought there was a pause, or they might not have had to do as much or as little. And we're finding that a lot of employers didn't realize they needed to still be maintaining the I-9 compliance, and there were a few more stricter criteria to address. And essentially what that means is more cost in time and potential penalties. So I want to address on this slide, again, the fact with the I-9 compliance regulations, they apply to all workers on US soil, and all employers need to understand that they are prohibited from continuing to employ an individual knowing that his or her work authorization has become invalid. That is point 2 of the regulation. That is something that a lot of employers we are finding let lax a little bit during COVID because there was confusion as to whether individuals could renew their licenses and their records and their status issues. And essentially, you are still on the hook. The other piece of this is, again, the regulations prohibit hiring any individual if you don't complete that I-9 process and verify the identity and employment authorization of the worker. Again, the COVID flex regulations versus remote worker regulations are very specific. I will go over those in the next slide, but we have learned that many employers just kind of let this stay on the back burner. They usually do, and it's now the time to make sure you followed through on anyone that to be re-verified. The piece I wanted to emphasize is that ICE, Immigration Customs Enforcement, usually does give, a 10-day period, or they give a small amount of time. If they identify issues, if there is a reporting of compliance failures by an employer, you usually do have a period where you can put together your good faith defense and correct deficiencies without penalty. But if you have a large workforce and you have widespread errors, this is where I said, again, the costs can drastically be increasing. This summer is when we expect a lot of these enforcement items to pick up again. So this quarter, next quarter is a good time to review the I-9 records on file. Next slide, please. All right. Here I wanted to just emphasize that all U.S. employers, you have to complete and retain the I-9 form for each U.S. employee. If you have employees that have been stuck abroad, if they're working remotely, they're still on U.S. payroll, the piece that we're finding employers didn't realize is that there are tax and employment possibly consequences to having a U.S. employee on foreign soil. There are countries that look at that as having an employer presence in, such as India and China, if you have even one worker there. And we have clients that have had a number of individuals in various visa statuses stuck in those 2 countries for a year. So re-verifying the I-9s and checking up on this, if there is corporate reorganization, if there are mergers and acquisitions, a lot of I-9 compliance work gets lost in the shuffle. So we want to remind everybody that this applies to everyone that's on US soil, but if somebody then ended up abroad, there is impact that we would need to look at on a case-by-case basis. The other piece of this I wanted to emphasize is that the unauthorized work piece, if someone has fallen out of status, it is really important that you have a standard policy in place. You're consistent and accurate across the board, and you're not discriminating against anyone, that if there is a violation that you terminate, you have clear guidance on how the benefits will align, or you have clear time periods for allowing somebody to provide new authorization. If there was USCIS directed, DHS directed flexibility during COVID for delays in being able to obtain documentation. In the next slide,
Naja, we have a couple of questions, but in the interest of time, At the end of your slides, can you provide your email address so these
Sure.
individuals can ask you directly?
Sure, I'm seeing that they're TPS, they're specific to statuses, so I will address those case by case.
Thank you.
Next slide, please. All right, so I want to emphasize to everybody that COVID flexibility is not allowed under the I-9 regulations for everybody. It is only if you are 100% remote workforce. So if anyone is going to the office, I have been going to the office for the nature of immigration work. We have to continue the I-9s as it stands, which is in-person verification of everyone's identity documents and employment authorization documents. If you have remote workers, this slide outlines the criteria that you must still have an authorized representative go in person. It can be a notary, it can be somebody, a lawyer, it can be a relative, actually. Anyone that's going to meet that employee in a state where you don't have an office presence, you still need to have somebody remote, I-9 the remote worker in person. The COVID flex, again, requires a policy in place that everybody went 100% remote at a particular date or time, and then it allows for verification of those documents through video chat and so forth. But once operations resume, and again, there's no clear definition, but once people are essentially, even one person is returning to the office, you have to go back to in-person document review and update that I-9. I can get into this again in depth for individuals that have case-by-case questions. The other piece of this is E-Verify. If you are enrolled in that supplemental process, it's in addition to the I-9 process, you can select from the drop-down online menu other and enter COVID delay for a reason why an employee was not entered in E-Verify in a timely manner from the date of hire. There doesn't appear to be a limit right now. So before, there used to be late entries had to be done within 30 days or it flagged the system for an audit right away. But we're having clients tell us that right now they've been able to enter late entries months after the fact. So for this, it's really important to keep checking the Homeland Security website and the USCIS guidance. It is changing frequently. And we definitely want to advise all of the employers on this call to go through your I-9 records, especially in light of COVID, because I'm assuming many people did switch to remote work, and ensure that you have the ongoing compliance. Next slide, please. Very briefly, the entry bans essentially mean that individuals that are abroad cannot come back into the US. Again, the visa-specific bans should not continue past March, but China, Iran, Brazil, the Schengen area, South Africa, there are areas where if you have individuals that were stuck, they still cannot come in. There are exemptions to that. We also wanted to highlight that the land border remains closed with Canada and Mexico. So we have plans in place and will work with any employer that has essential workers basically stuck in any of these regions. There are ways to get them in, but overall, travel is still very much being impacted. Next slide. Keep in mind that consulates and embassies across the world have been closed, and then it's case by case based on location. When they're reopening, US citizens are also still stuck abroad, but they are now getting emergency and priority service as the consulates start opening. Just again, be prepared if you have any type of international workforce. Again, even if you're not a sponsor of immigration on behalf of your employees, travel is going to continue to be an issue through the summer. Next slide, please. The next 3 or 4 slides just highlight the fact that if you do have H-1B workers, COVID has an additional demand on it because H-1B work is specific to a location. So if somebody moved to their home work site, there are processes that had to be put in place or the visas can be invalidated. Again, I'm happy to go over this with everyone. Again, it's more fact and case specific, but I wanted all of the employers on this call to have access to the guidance at least, because I think it's kind of fallen to the side again that you have to follow up on H-1B workers. Next slide, please. In particular, if you have had furloughs or you have had reduced payroll or reduced hours for H-1B specific workers, again, that is not possible. It can invalidate the visa, and benching these workers is illegal. They have to be paid a certain threshold and work a certain threshold. So again, the guidance is here, and I'm happy to discuss that. Next slide. This is, again, just reduced hours and termination, very particular for H-1B workers. Again, this is, the highlight here is if you think you have any type of visa status workers, they need to be reviewed in a special way before you reduce hours and terminate. Next slide. And then I wanted to just highlight right now we were getting a lot of questions about unemployment benefits. H-1B and other visa status workers, you have to be very careful because you can't assume they qualify for benefits. Employees must meet federal and state guidelines, and states are very specific. In New York and Connecticut, you have to be available and ready to work. And when you're being sponsored for any type of visa status, you're not available and ready to work. You require an employer sponsorship to be able to work. So there are particular statuses that need to be reviewed where people would not qualify for any benefits. Next slide. And the last thing I really wanted to emphasize for all employers is that be sure you understand the government processing delays. Business travel is not considered an emergency, and we have a lot of employers picking up even state travel, interstate travel again, expecting employees to be traveling. There are significant delays. Again, passports, TSA PreCheck, global entry. I'm getting tons of questions. Global entry is automatically renewed for a year if you start the application process, but it's going to take significant time. Immigration and business realities don't align. 6 months to a year in advance, applying for passport renewal and things of that nature, it could be over a year before you actually get results. And one of the key things I wanted to point here is, as of January, all passengers ages 2 years and above are required to show a negative COVID viral test to get back into the US. So if you have specific questions about, again, safeguarding your employees and getting them back to traveling in and out, please do not hesitate to reach out after this, all right? I will let Mary take on her presentation, and I will address the questions in the chat. Thank you.
Thanks, Patrick.
Good morning, everybody. Last but certainly not least, we want to go over some wage and hour changes. We know it's a lot of material, but it's all important. And again, I just sent a bunch of email addresses for anybody who needs to email questions afterward. We're here. So go to the next slide, please. So just to run through the topics that I'm going to try to cover in the next 15 minutes, we're going to talk about changes you can expect on the independent contractor analysis front, opinion letter issues revoked, tip pooling, which we'll just give honorable mention to, diversity training, the joint employer rule, federal contractor issues, end of the PAID paid program, and other predictions. Next slide. So let me just also give you this disclaimer. We're getting changes every day. In fact, we've been amending these slides on an almost daily basis. So you should all be very, very in tune to some of the changes. So this is the best we could do as of yesterday. There will be more changes under the administration. Even if you went to the U.S. Department of Labor website, it has that disclaimer that there's going to be policy changes. So let's talk about independent contractors. So under the prior administration, there was some attempt to loosen up the rules regarding how you analyze whether somebody can be properly classified as an independent contractor. And so there were two core factors that the administration said you would look at, and it was the nature and degree of control the business has over the worker and whether the worker has opportunity for profit and loss based on initiative or investment as a business owner would. So that was considered as a loosening of the multi-factor test that the federal government had and many states. So states have their own set of factors that are applied depending on the nature of the analysis you're doing. So for example, if you are considering whether somebody should have been classified as an employee for unemployment compensation benefits, there were a series of factors that you have to apply. And so this is where it was headed before the new administration. So now it's on hold. The Biden administration has extended this through May 7th, 2021 to consider it. Next slide, please. So these are some opinion letters that have been revoked already by the Biden administration. And one of them was this January 19th. On January 19th, they revoked the analysis that was starting to be conducted under the Trump administration Department of Labor. And there are others, and there's another one of April 29th, 2019. There was an opinion letter that said gig company workers are exempt from wage protections because they're independent contractors. So we need to add that's been revoked as well. Next slide, please. So now this 5-factor plus test is coming back into play. And it reaffirms what we call an economic reality test. And so there are multiple factors now that the Biden administration is bringing back. Is the worker free? So this is the ABC test. We have it in Connecticut, we have it in New York, and now they're adopting it, readopting it on a federal level. Is the worker free from control and direction in connection with performance of the work? The worker performs work outside the usual course of the hiring entity's business, and the workers customarily engaged in an independently established trade, occupation, or business of the same nature. Now, this is an and proposition. It's not or. So, for example, in Connecticut, for determining whether or not somebody's entitled to workers' compensation benefits, you have A, how long is the leash? Are they free from control and direction of you? So let's say you have a staffing agency, and they send somebody to your shop and they're working your hours doing what you tell them to do. And they are, even though they're from a staffing agency, you consider them a contractor, you're going to have an employment relationship either through a joint employment theory or directly for certain purposes. So the second part of the Connecticut test, for example, is the worker performs work outside your usual course of business, or, and we have an or under this second bullet in Connecticut, or they don't perform any work at your locations. This looks to be something they're eliminating under the rule they're trying to adopt. Here's what that means. Am I doing something that is in your normal course of business? So if you are a retailer and the plumber comes in to fix the sink in the restrooms, that's not in your usual course of business. And the workers customarily engaged in an outside business doing the same thing for others that they're doing for you. So remember, this is an and the focus is on what's actually happening, not what you have in writing with this contractor. It's what actually is happening. Next slide, please. So while this has been extended, I would suggest you should anticipate we're going to go back to this other factor test that's going to make it much more difficult, or return to it being much more difficult for you to classify workers as independent contractors. Now, just again, some honorable mention to tip pooling. So we had a rule that the Trump administration was trying to employ, that you can take a tip credit for time that the employee in a tipped occupation performs related non-tip duties, either at the same time with or a reasonable time immediately before or after performing tip duties. So that is like the server who spends some time cleaning or preparing a salad or taking reservations or mopping the floor. So what they were trying to do was loosen the rule about when you can take a tip credit. The Biden administration looks like it's not going to allow a tip credit for non-tipped duties. So stay tuned for those of you in those industries. Next slide, please. Now, some of you may have heard that there was a revocation of diversity training, diversity and including training for federal agencies and federal contractors because of the inclusion of some what was called divisive concepts, like the terms white privilege or institutional racism. So that training was on hold. The current administration now has said that's revoked. They're going to have the Department of Labor review and consider rescinding all agency actions that stemmed from that original executive order. And they're also shutting down a tip line, which was by phone or email, to encourage employees of federal contracts to report, quote, un-American, unquote, diversity training. So we can expect diversity training is going to be brought back. You may remember the prior administration had problems not only with these terms of white privilege and institutional racism, but it was encouraged for employees to report training that denied the country's history. And so stay tuned to that. For those of you who are federal contractors or subcontractors of federal contractors, it may apply to you as well. Can you go to the next slide, please? There's also been a lot of fluctuation between administrations before Trump, during the Trump administration, and now after about who is a joint employer. So during the Trump administration, they were trying to tighten this up by having two scenarios where you would be a joint employer, and that made it a little bit better for some entities to say, we're not joint employers for purposes of wage and hour violations, discrimination laws, and so forth. So this was challenged and was on appeal. So now the Biden administration has already sent a new proposed rule for review on it's already yesterday, for review yesterday. So you need to stay tuned to that. It is expected that they will again make it easier for workers to claim a joint employer relationship. Next slide, please. Now, there was an executive order where protected federal contractors and their subcontractors, from certain of them, from allegations of workplace discrimination. And then the exemption's been limited to religious organizations, nonprofit religious organizations who have contracts with the federal government, where it allowed these religious-centric organizations to favor people of a particular faith. And of course, it depended on what tasks they were performing and so forth. So the prior administration extended the exemption in terms of the definition of religion exercising organizations, and extended it to closely held corporations who could avoid these claims based on religious beliefs. The Biden administration is going to rescind this expansion, and they've asked for a notice and comment period. So for those of you that fall into this category, please stay tuned for that. Next slide, please. There was a program put into place, sort of an amnesty program, whereby employers could voluntarily report that they had violated minimum wage and overtime violations under the Fair Labor Standards Act to avoid litigation, penalties, or excessive damages. They couldn't avoid the wages that were owed, but they could avoid some of the penalties for intentional violations. And it also suspended the right of affected workers to take private action on the identified violations when an employer voluntarily brought this forward. So the Biden administration's position on this program is that it deprives employees of earned wages, and that the Department of Labor already has sufficient resources to allow people to bring complaints and to help people understand their responsibilities under the Fair Labor Standards Act and various state laws. And so you can expect that this program is over. Next slide, please. I'm just going to point out this slide. Mike has really covered this OSHA guidance. There are some whistleblower protections under OSHA that are still in place. but there's going to be a renewed commitment to whistleblower protections under OSHA. Those are employees who call about violations in the workplace under COVID guidance, and as it has been in the past, about violations of any other OSHA standards. Next slide, please. Now, here's some other things that we expect you should stay tuned for. The push for a $15 an hour federal minimum wage. That's being bantied about already, so stay tuned. Now, again, this was mentioned already by Josh. There are various states that enacted the right to work laws. We think you can expect that will be repealed. And we also think you should stay tuned to the administration use federal contracting to achieve certain goals, like debarment of employers who illegally oppose unions, restoration of the Obama administration's Fair Pay and Safe Workplace executive order, which required agencies to take compliance into labor laws into account when awarding any federal contracts, and preference for employers who do pay at least $15 an hour minimum wage when awarding federal contracts. We also note that there was a prior executive order about reporting on your EEO-1s, certain compensation information. That may be something that's another focus by the EEOC going forward now that their budget is being expanded. We're now at 10:33. Larry?
I think that's it. Good job getting us back on time, Mary. So I just want to thank everybody for attending. I know we compressed a lot of information into a relatively short time period. Do feel free to take advantage of our invitation to send us emails with any follow-up questions. We're happy to answer those. As mentioned at the beginning, you'll be getting an email with, I believe, a recording and the slides, so you'll have those, and we'll let you know about the HR continuing education credit. Hopefully we'll get that resolved soon as well. We look forward to seeing as many of you as possible at the next program. Hasn't been scheduled yet, but probably sometime around Memorial Day or so. Hopefully we'll be on the way out of this pandemic by then. Thank you very much.